your determination or putting in your best into this is the best thing that can guarantee you that particular fit. So once again, I wish you all the best as you continue your journey. Okay. So we take on today's class. Can you hear me, please?
Yes, sir.
Yes.
I didn't even hear any.
Yes, sir. We can hear you, sir.
Or you don't want the price?
Amen, sir. We can hear you. Amen. Thank you, sir. Yes, sir.
Thank you very much, sir.
We don't care.
Okay, so last week we began by looking at sources of Nigerian law, and we have looked at Nigerian legislation. We've also taken time out to look at the legislative procedure in the various houses. And in the course of the week, I think on Monday or thereabout, the Speaker of Lagos State House of Assembly was impeached. And I was like, just when I was thinking about, will it not be ideal if we take a tour to actually look at the practical aspect of these things, especially within our vicinity here, that is the Lagos State House of Assembly. And I think it was when I was thinking about that, I got the news of the impeachment of the speaker. All right, but that notwithstanding, maybe if time permits, we may take that journey. If not this set, maybe the coming sets. All right. So last time we met, I was discussing case law, which is otherwise known as judicial precedent. And we've talked about basically what judicial precedent is all about. We've looked at the nature of judicial precedent, and then we paused at when we were looking at, I was supposed to look at the subtopic ratio decidendi. Now, speaking broadly on the nature of judicial precedents, we did establish in the course of that class that there is no precedent that is reached in vacuum. That for any judgment to have been given, it is usually at all times based on facts, law, and then maybe what we generally refer to as extrajudicial factors. And then, in the midst of all of that, there is always the reason for the decision. The court must provide that. That's why we're saying that for there to be a precedent, it must have gone through what may be described as the judicial lawmaking process, even though we have established that the judiciary does not make law. So this is, the nature of judicial precedent. Mind you, we are looking at case law or judicial precedent as a source of Nigerian law. So we'll take on the first subtopic, ratio decidendi. And the ratio is the normal ratio, why the word decidendi is spelled D-E-C-I-D-E-N-D-I. And it's an offshoot of the course of the topic that we're looking at before. Now, we continue on this subtopic. In order for the doctrine of judicial precedent to work, okay, it is very necessary to be able to determine what the law is actually talking about, especially in the course of delivering a judgment. And usually, like I said, the court will look at the facts, the law, and then arrive at a conclusion. So, the judge will usually set their reasons for a decision in every judgment. And the reason will amount to what is popularly known as ratio decidendi of the case. And the ratio decidendi forms the legal principles of that case, and it becomes a binding precedent that must be followed in future cases containing similar material facts. Of course, when you look at the concept of judicial precedent, we understand the fact that the essence is to be able to reapply that case which has become a law by virtue of the judgment that has been reached, and applying it to a subsequent case with a similar fact. So, and if that is to happen, usually the judgment must have come to play by the fact that the court has followed the due process that is required in the process of adjudication. And then the court brings out the principle of law upon which that decision is based. And once that decision is reached, it becomes binding. And that's why the court is always very careful in arriving at a decision, especially courts of record, where the proceedings of court are recorded. They are always very careful because whatever it is that has been arrived at becomes a precedent that lower courts or the courts generally may follow if there is a need. So ratio decidendi simply means the reason for the decision made. What decision has been reached, or what judgment did the court put forward? What is the reason behind it? Is what ratio decidendi simply means. Now, according to Michael Zanders, Zander is spelled S-A-N-D-E-R, is saying that ratio decidendi is a proposition of law which decides the case in the light or in the context of the material facts. I'll repeat that definition as provided by Zanders. It says that ratio decidendi is a proposition of law which decides the case in the light or in the context of the material fact. Of course, that takes our mind back to the fact that I said earlier that before the courts of law can pronounce a judgment, the fact of the case is central to that decision. The fact of the case and the available law as canvassed by parties to the suit. Because in every transaction, I mean a case in this form, we see that lawyers that are engaged will have the duty to make case for their clients. And in doing this, they go all out to make several arguments for the success of their clients. And in making such proposal, such argument, they refer to several provisions of law. Even sometimes they make reference to cases that must have been decided in time past. And then it is based on that that the court usually arrive at the position of law, which comes out as judgment in that particular case. So, the fact of the case is usually very crucial, and also applicable laws. And applicable laws, of course, like when we have used the word laws, means that there may be, series of laws that a legal practitioner may choose to engage in making his arguments to ensure that the court finds in the favor of his clients. So that's an expansion of the definition provided by Sanders. Also, the term ratio decidendi has been used to describe the principle of law on which a judicial decision is based. Ratio decidendi has also been defined as a principle of law on which a judicial decision is made. So, what it simply means is that it is the point of law that determines the judgment or the ruling. Like I'll jokingly say that even if a judge has been compromised to either give a judgment in the favor of a party, the judge as always will always look for a better ground, a principle of law to base such arguments. So that talks about the fact that resting a decision on a valid point is crucial. So it is the point of law that determines the judgment or the ruling. That's what ratio decidendi is. All of these definitions still revolve around the fact that ratio decidendi is the foundation of any judgment or ruling that is delivered. Also, it can also be referred to as the legal principle or rule that has been established in the case. Like I said earlier, that when an advocate is making a submission in the court, he refers to several cases. So all of these also, if the court should agree with such submission and base its ruling or judgment on such, that is tagged or known as ratio decidendi. So we need to know and also register it that ratio decidendi is the most important part of a case to grasp and also remember as our lawyers to be. Once a judgment is given, the lawyer is looking for the reason for that decision, while the rest of the facts may be forgotten because it is part of a case that has authority. But what is expected that you grab is the reason for that decision. And the fact that while a fact may remain a fact forever, the decision of the court remains a binding judicial precedent, which other court may engage or follow when they have similar facts before them. So, on the other way, we can also submit that ratio decidendi is also made up of material facts. So, therefore, if a ratio decidendi, for example, is to be applicable in a similar matter, the facts of that case must be the type that have some form of similarity with the one upon which a particular judgment has been given. So, therefore, it is only the pronouncement on law in relation to material fact before the judge that constitutes a precedent, not the facts alone. Of course, the decisions, the pronouncements are made based on material facts. But what constitutes a binding precedent is the position or the ratio, that is the reason behind that decision. So therefore, the ratio decidendi is a very important aspect of every case. So that is one aspect of judicial precedent or case law. Another aspect that we are going to look at in this class is what is known as obiter dictum. Obiter dictum, which is spelled O-B-I-T-E-R-D-I-C-T-U-M. Obiter dictum. Okay? So what does this mean and how does it relate to the course that we are looking at right now? Obiter is a Latin word that means by the way, just by the way, or in passing. So, in the course of delivering a judgment, it is not everything that is said by a judge that constitutes a binding precedent. Some are considered as obiter because their statement made in passing or by the way. That is to say that where ratio decidendi stands, obiter dictum stands, ratio decidendi will always at every point in time remain a very important aspect of a particular case. So it is the ratio decidendi that constitutes a binding precedent and not the obiter dictum. Even though the obiter dictum may be contained in a judgment, it is only of what we call persuasive effect. We will explain that later on when we look at the various types of ratio decidendi that we have. So, like I said, it is only the pronouncement on law in a particular case that is material. So any other pronouncement on law made in the course of a judgment is an obiter dictum, that is a statement by the way, and then it is different from the ratio decidendi. Example of obiter dictum includes explanations. Okay? Just like when I'm teaching you or we're having a class, sometimes we have to deviate for the purpose of driving home our points. So we give various explanations that sometimes it's as if we have left the substance of the topic into another thing. But all of that are necessary for you to understand. So in a judicial proceedings at the same time, there are times when explanations will be required. There are times where analysis will be required. There are times when illustrations will be required. But all of these are saying by the way. Other types of, obiter dictum, other things that we can also talk about opinions. We'll talk about analogies. Suggestions can be made. Even observations can be made, or even hypothetical cases can be developed in the course of such judicial proceedings. But all of these does not form the ratio decidendi. They are classically classified as obiter dictum. I've been in a court before. It was a murder trial, and I was serving during my NYSC days with the Rivers State Ministry of Justice, and it was a murder matter we were prosecuting. And then we had to bring in class. I hope you can hear me.
Yes, sir.
All right. Thank you.
Yes, sir.
All right. So, as counsel representing the states, we had to bring in an expert, a medical doctor, whose area of specialization has to do with the autopsy. And then it got to a point that the court required that the doctor, I think that's people we call are they pathologists now? I can't remember the name we call them.
Yes, pathologists.
Okay. So the court wanted to examine the cause of death because that is usually also very central when the court is to arrive at a decision. And the court asks to require the pathologist to explain what led to the death of that individual. And then the doctor needed to explain how when there is an injury to the head, it affects blood flow and it affects the brain. And once the brain is affected, it's like that's practically the end of the individual. And the pathologists try to explain the process of decapitation. Because I think in that case, if I can still remember, the disease head was cut off. But there was need to establish some other aspects of some of the physical mark on his body. So the pathologist needed to explain what led to the death before the head was cut off. And then all of us that were in the courtroom that day probably forgot that we were in the courtroom. We were listening to these explanations by the pathologist. And then the judge also picked it from there in the course of the proceedings to repeat some of the things the pathologist said, probably for the purpose of having proper records. And the judge made some statements about the explanation that the pathologist made to the court. So all those statements that were made by the wayside in the course of listening to the explanation of the pathologist are statements made by the wayside. Even though some of those explanations also form the fact from which the court will extract facts that are considered to be important to form the ratio for the decision of the court. So that's why we have all of those as examples. The pathologist happens to be an expert witness who is qualified to give an expert opinion by virtue of his training. Even with the level of the knowledge that the court must have acquired, the court does not have the requisite knowledge to talk about medicine. But the testimony of the pathologist amounted to expert opinion or testimony, which the pathologist gave, and the court was able to work on the statement or the explanation that the pathologist provided. So, obiter dictum are statements by the wayside, which can come by way of analogy, which can come by way of opinion, suggestions, analysis, explanation, observation, and so on and so forth. So that is another very important part of every decision. Now, let's look at ratio decidendi and obiter dictum side by side. Okay? In order for us to be able to drive home our points, and then we will see how we can apply a case or two to be able to have a better understanding. So when we're talking about ratio decidendi and obiter dictum, again, we say that ratio decidendi of a judgment is the principle of law stated in the judgment on which the decision in the matter is based. In contrast, a statement of law is obiter dictum if it does not form the basis of court decision in the case that is being tried. Meaning that that statement of law or that law is not binding, but at times it enjoys what we call persuasive force, in that the lower court could engage such statements to either do justice to a case at hand when something is compulsory, is binding. If it is of persuasive effect, is to the effect that, oh, you may choose to take it or otherwise. You can consider it. It can serve as a guiding point, in a similar case that may come before the court.
Sorry, sir.
Yes, please. Nifemi, go
Sir,
ahead.
can you please
Sir, sir.
what you just said?
All right,
On the
I can see that you okay. Let me just take the questions, but I hope we will not deploy the entire time for question. Okay, let me hear you again, please.
No, I'm not asking a question. I'm just saying that can you please repeat the definition you just said for like the differences between ratio decidendi and the other one?
Okay, so I said ratio decidendi is the principle of law stated in the judgment on which the decision in the matter is based. While on the other way around, Obiter dictum will not form the basis of court decision in a case that is being tried. Okay? Because if it is a statement of law or an explanation, it's just by the wayside. It does not form the basis of the judgment. And then it does not enjoy a binding effect. Rather, it enjoys what we call persuasive effects. Now, let me give you an example of what we're talking about in a dissenting judgment. In the case of Donogun versus Stevenson, I'm sure you must have heard of this in your law of contracts. Have you?
No, not contract, sir.
You've not?
No contract, however.
Not contract, but legal method.
Legal methods.
Sir, that is the case in law of thought, sir.
Okay. Okay, yes, that's thought. Yes, that's thought. And I think one way or the other, it finds the fact in that case will also find its way, in contracts, one way or the other, maybe when you look at the facts and all of that. So in this case, the plaintiff, a retailer, bought and consumed a bottle of ginger beer. And the question was whether the manufacturer owed the customer a duty to exercise care in making of the ginger beer. And the court held that he did, meaning that he has a duty to take into consideration the health of those who are likely to consume the object. So the reason is that the manufacturer must have contemplated that the ultimate consumer of the ginger beer might be injured if proper care is not taken in the production of the ginger beer. Okay? Now, the court feel that this manufacturer, you have a duty to ensure that you produce whatever you are producing to the point that it will not bring any harm to the individual. So it was at this point that Lord Atkin, spelled A-T-K-E-N, proceeded to formulate what we called the neighbor principle. Okay? All of this was happening in a case that was ongoing. So that's why, of course, in order for the court to arrive at the decision of that they give out, they engage into a lot of judicial, they call it judicial activism or judicial are digging just to ensure that they're able to get accurate, good judgment. Now, Lord Acton submitted, and I quote, he said, the rule that you must love your neighbor becomes in law that you must not injure your neighbor. And he went forward to say that, and a lawyer's question, who is my neighbor, received a restricted reply. You must take necessary care to avoid act or omission which you can reasonably foresee will be likely to injure your neighbor. Who then is in law is my neighbor? The question seemed to be persons who are so closely and directly affected by my act, and I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the act or omissions which are called in question. That is the submission of Lord Acton when we was trying to explain the neighbor principle as to whether or not this manufacturer hold the final consumer a duty of care. So in this case, the neighbor principle, although a formidable principle, enjoys only a persuasive authority because it is an obiter. Because the court did not say that the reason for the decision of this court is based on the neighborhood or neighbor principle. So therefore, it remains an obiter. This was an analogy or a submission or a postulation that the court made in the course of a judicial proceedings. So that takes us to the types of precedent that we have. There are two types of precedents. Remember, we are talking about case law, which is also popularly known as judicial precedent. So there are two types of precedent. One is what is known as authoritative precedents or decisions, which are binding. I'll repeat that again. Authoritative precedents or decisions, which are binding, while the other type is the persuasive precedents. And from all that we have been saying, we can easily affirm that ratio decidendi comes under the authoritative decision or authoritative precedent, which we can also refer to as binding precedent. Why obiter dictum we come under the persuasive precedents. So what it means, therefore, is that if a case is cited in court, it may be binding in a subsequent case if both cases are materially identical. So when a judge indicates that the case cited is not binding, he is saying that the material fact of that case and those of present are not the same. And then he will come to a conclusion to distinguish both. And usually much argument is put in place to separate the facts in order to be able to say, yes, this is of a similar fact and the other one is not. Joy Adeneko, you can ask your question.
Yes, I wanted to ask, you said my network logged me out. You said that there are the types of precedents. I didn't get that part.
There are two types of precedents. One is authoritative or binding precedents. The second one is persuasive precedents. Okay?
Okay, thank you, sir.
All
Thank you,
right.
sir.
So that's for that. Now we also move on to look at another subtopic known as stare decisis. Okay? Stare decisis. I'll spell stare as S-T-A-R-E. Decisis as D-E-C-I-S-I-S. That is decisis. So what does that mean?
Sorry, sir. I
Yes,
have a
please.
question.
Yes. How many
Sir, this
decisis are you using?
just one.
And why is it? Why is it?
Probably the network.
All right, please go
I
ahead.
I stay in a rural area, sir.
Is that
Sir,
what?
please. I stay in a rural area.
Come to the city.
All right, sir.
Oh, yeah, go ahead.
Yes, sir. After you mentioned the two types of precedents, you were explaining something about distinguishing of cases. I didn't get that, sir. Thank you.
Yes. What we are saying is that when a judge is to use a particular case that had been cited either by a party, recall that the foundation to our submission is that before that case law can be applicable to the present case, they must have identical facts. So when a case is cited, the judge will take the duty to consider whether the two cases are the same before the court can apply that case. So that brings about what we call distinguishing. The court needs to distinguish between the two cases in order to be sure that one of it has connection with the new one that is before the court. Do you get it now? Adeneko, are you with us? Okay, maybe she has gone.
Yes, sir. Thank you, sir. It's
All
my
right.
network.
Okay. So that means you are missing unilag now. Okay, let's go. Williams, you were going to ask a question.
Yes, sir. Yes, sir.
Go ahead, please.
My question is still based on this equation that you made mention of now.
Can you speak up a little, please?
Sir, I said my question is based on this distinguishing that the court has to do between cases that you made mention of now. Can you hear me, sir?
Very well, very well.
Yes. So basically, I just want you to like explain it again because like my network is also bad over here, so it was just like it was cracking a bit. So I couldn't hear what you
Okay,
were
what
saying.
I mean is that when a case is, when a case is going, when it's a judicial proceedings going, parties are bound to cite cases. But that's where you don't use case law in your office, you use it in the courts. So when you are making your submission and you refer the court by saying, I commend my lord to the case of Donogun versus Stevenson, that the court held that, for example, that the producer of a consumer good holds a duty of care to its final consumer. That decision may have been reached on a different platform for a different reason. So if such case is cited where it involves issue of production of maybe services, and somebody is citing the case of Donogun versus Stevenson relating to goods, and this one is relating to service, what we are saying is that the court will have to verify that the case that is cited and the present case do they have anything in common? Because we did say that the only reason why a case can be applied to the present one is if they are the similar facts. So the court will verify. Just like sometimes some of you, when you are writing exams, you can quote laws that does not exist. We have seen that very well. You can quote cases that does not exist. Maybe you have forgotten the case. You just put one case and provide one wrong citation. If we don't cross-check, we may be carried away by the fact that you have used red biro to write the case. And that reminds me of a colleague who decided to apply similar wisdom when he was asked to write 10 Latin maxims. He has written about 9 and he could not remember the third one. I mean, the 10th one. What he decided to do was to just write something like requese. And in interpretation, he puts what will be will be. And there's nothing like that. So if the lecturer who was marking was not careful, would have just awarded 10 marks for the 9 correct answers. So the court is duty bound to, after listening to the requese, to confirm whether that case and the case at hand, they are of similar facts. Do we get it now?
Yes, thank you, sir.
All
Yes,
right,
sir.
so I can move on now. So I was talking about stare decisis.
Yes, I'm sorry, sir. Sir, I have questions as regards ratio then that before we move to start decisis. Should I ask?
Yes, please.
Thank you, sir. Okay, so like I feel there are peculiarities to the application of ratio decidendi that we have not discussed. Like I don't know if we are discussing later, but I just felt like since we're moving to start decisis, we may not discuss it again. Like I don't know, it's weird. Me now, as of late, we have been having to read some law reports. I find it hard to find the ratio decidendi, and really, I mix it up. I don't even like reading from NWLR. It's always very. I
Well,
just don't like reading. I find it hard to find the ratio decidendi,
where you see, there's
and I
no.
also.
Okay, go ahead. I'm listening to you.
Okay, and I also feel that judges like I feel there's a peculiarity to ratio decidendi in that different judges can on similar facts make up different ratios. Then how would a lawyer or a judge find that ratio that will be peculiar to that particular fact? I just feel like the application is complicated because you can have like 10 ratios, and if you look at the facts of those cases, they are similar, but a judge may pick it up and say it does not apply to this case. So yeah, the peculiarity is application and also the identifying of what the ratio is in a law report. Those are my questions.
Okay, I think I like that. But I would like to ask you a question. Sorry, I'm not using question to answer question. What is the definition of law by Oliver Wendell Holmes?
The prophecies of what the court will do are nothing more pretentious.
The
Not only
prophecy
by
of what the court will do are nothing more pretentious.
Okay. So a court can choose to pick a particular. Please, can you mute your mic? Okay. So hello. Are we good now?
Can hear you.
Okay,
Hey, sir.
all right.
Sorry, sir. Oliver Wendell Holmes defines law as Judge Oliver defines law as a prophecy of what the court will do and nothing more pretentious.
Okay, okay. So what we are saying is that because the person who asked the question said that, okay, sometimes it can be difficult to identify all of that, that there is even sometimes the court will pick what they consider to be what is the ratio, which to them may not really be. And the point, how I ask the question, it is what the court thinks, what the court says that is final. And in a case, there may be 10 ratios depending on the issues that is before the court. If the court is to determine 10 issues, for example, let's look at a case of Mr. Clark. Mr. Clark has been arrested for armed robbery. In the course of armed robbery, there is an evidence to show that he worked in hand with the security man of that company, meaning that the case of armed robbery, the issue of armed robbery is there. Issue of conspiracy is also there. Issue, let's say in the course of the robbery, somebody was killed. Issue of murder has gone in. Let's say in the course of the incident, somebody was raped. Issue of rape has gone in. So meaning that there are 4 issues which when the individual is being tried, those 4 issues may be expected to be talked about. And at every point in time, when the court is to give judgment, it needs to address those issues that have been raised. In giving or passing judgment, the court must provide reason for every decision on each issue. So if there are 100 issues that the court needs to answer yes or no to, the court must provide ratio decidendi. So you may find ratio decidendi in, many in a particular case, depending on what is before the court. Then, before you can get the ratio, you have to read probably the entire judgment. Even though in some law reports, for lazy people, they just provide the issue, they provide the ratio, and they provide the judgment. But of course, if you only read the issue, the ratio, and the judgment, you may not have you may not have really, have a good grasp of what the particular case is talking about. So you have to still read it, and that's why you are undergoing these studies, this training, and much is also expected of you. I hope I was able to answer your question.
Yes,
Hello?
sir. Yes, sir. You did. You addressed a part of the peculiarities, but I have a question on application. Like, how do the courts apply ratio decidendi in future cases?
Okay. Now, let's take, for example, where we looked at the case of Donoghue and Stevenson, where the Lord Acton developed the neighborhood or the neighbor principle. Let's say that the court based its judgment on that principle, okay? And then somebody now cite the case in a subsequent case. Now, what the court will look at is that what principle did Lord Acton base his decision on? And the decision is that a producer of a consumer good owes a duty to prepare it under a very hygienic condition. So if now you are the one producing Bonvita, and in the course of producing it, you didn't take reasonable care, and maybe one gecko jumped into the can, and then you bottled it like that. And somebody, after you have supplied it, somebody went into the supermarket, picked that particular can, without knowing, without looking at it, just started scooping the thing and decided to scoop your wall gecko that you have packed into it, and then the person ate it, only for the person to start having stomach upset and all of that. The thing is that you have violated that requirement. So the current case we now look at is that, is it like a similar case? The one in that case of Stevenson happens to be ginger beer. Why this one relates to Bonvita, for example? So the court will see that they are of a similar fact, because it has to do with production, it has to do with consumption, it has to do with injury on the consumer. And that's how the court applies those ratio decidendi. Do you understand now? Though there may be advanced way of doing this, but that is the simplest that I can provide.
Thank you, sir.
Thank
you, sir.
You're welcome. So let's make progress. We're talking about stare decisis. Stare decisis simply means stand by things decided. That is the meaning of stare decisis. It can also mean keeping to the ratios of a decided case. And of course, that was why we're talking about binding precedents. All of these they are connected together. That's why sometimes you see that you cannot talk about stare decisis, judicial precedent, without talking about the doctrine of stare decisis. If that particular decision is binding, especially because it applies to the case at hand, you have to stand by it. And what the stare decisis simply talks about is that it is a doctrine of judicial precedent that a court is bound to follow earlier judicial decision of a Supreme Court, of a superior court, sorry, in the same hierarchy. So what it means is that, let's take for example that it was the Supreme Court of Nigeria who gave the judgment on Donoghue and Stevenson, that the ratio is, if you are a producer of a consumer good, you have a duty to take reasonable care. If you don't take reasonable care and your consumer come to any harm, you are liable. Then the Court of Appeal must follow that decision if it is cited in a case that is before it. Nifemi, you can speak.
Sir, please, can you repeat the last definition that you just gave now?
We have to be very careful of time. The exam is knocking seriously. So don't take us back. But we do well again to recap. So I said
that is
to stand by things decided. Nifemi, can you please mute? Or keep to the ratio decidendi of past cases. So I now went further to say that the doctrine of stare decisis is a doctrine of judicial precedent that a court is duty bound to follow earlier judicial decision of a superior court in the same hierarchy when the same point arise again in litigation. I believe from the explanations that we have made, you are already in the best position to understand what stare decisis is all about. So simply put, the doctrine of stare decisis is that when a point or principle of law has been officially decided or settled by a ruling of a competent court or a judge, it is deemed that other courts that are below it may have to follow that decision, especially if it relates to the same or similar fact. As a matter of fact, the doctrine preaches the fact that you can no longer subject that ratio decidendi or that law to open examination or a new ruling. Rather, you are bound to follow it, except if indeed the facts of the two cases are not the same. Okay? So, and also except in some exceptional cases. What are these exceptional cases? Now, one of the exceptional reasons as provided by Lord Reid may arise when the ratio decidendi of a previous case does not accord with authority, or it was poorly arrived at. Let's say, for example, a judgment was obtained by fraud. Of course, automatically you know that it was not gotten on merit. So, if such can be, established and the court had to bring it down, what it means, therefore, is that the court may vary, may look for a way to vary, especially if it is a court of record as well. So, what stare decisis does is that it imposes an obligation on lower courts to follow relevant decision of superior court as a matter of law, not by choice. And the purpose of doing that is to make room for certainty in our judicial system and to bring about stability, so that when the same facts are the same law should apply. And then this only helps us in developing our judicial system. Okay? Now, if, for example, like I said earlier, let me repeat again, because of what Lord Osprey said, that if there is a question as to how this particular law was reached, then it may be necessary to review the fact leading to the judgment. And this is to prevent, continuous imposition of wrong judgments at the expense of justice. So, therefore, the higher court sometimes, in order to prevent the continuation of circulating erroneous judgments, because if such is allowed to trend in the judicial system, it will only humiliate or make ridicule of the judicial system itself. So, In cases like that, a court may choose stylishly to avoid the application of that particular law. But what we are saying is that by virtue of the doctrine of stare decisis, a lower court is duty bound to apply the decision of a higher court when they have similar cases before them. Okay? So let me take Ubong. You have a question?
Yes, sir. Good morning, sir.
Yeah. Is your name Charles or Charlie?
Charlie, sir. Charlie,
Charlie boy?
not Charlie boy, sir.
All right. Go ahead with your question.
Okay, so, sir, I want to understand what if the decision was reached by a lower court? Is the higher court's duty bound also to stand by the decision, or is a principle only in duty on the lower court to follow the decisions reached by the higher court? Can it also be the other way around?
Your network is not allowing me to hear you properly. Can you repeat?
Okay, sir. So, sir, I'm saying that concerning this principle, what happens if the decision was reached by a lower court? Is the higher court duty bound to follow the decision, or is it only the lower court that is duty bound to follow the decision
The higher
made by the
court,
higher court?
yeah, the doctrine does not work like that. The doctrine works from the higher court down. Why is it so? Let's just look at the brain behind such position. Is that, okay, for example, I'm a lecturer on this course, and Professor Olaniyan is also a lecturer on this course. He has spent about 3 decades, that's over 30 years, teaching this course. His experience, his exposure on this subject cannot be compared to mine, who probably have done like about 6 or 7 years on it. So it is believed that the superior courts have better capacity to make such judgment that the lower courts can follow. That's one simple way of looking at it. Okay, because before somebody is appointed as a Supreme Court justice, he or she must have gone through the various lower courts, like I was listening to the profile of the then Chief Justice of Nigeria, my Lord Mukhtar, the first female Chief Justice of Nigeria. She was the first magistrate to be appointed in the North, the first female lawyer, the first magistrate, the first, I think she also sat in Sharia court, the first High Court female judge, the first Court of Appeal justice, female Court of Appeal justice, and also to the Supreme Court, even to the point that she had to head the Supreme Court. So with her wealth of experience, she will do better than someone who is just starting at the lower courts. I believe I've been able to answer that question.
Yes.
So we move on. We want to look at disadvantages of judicial precedent.
Hello, sir.
Yes, please.
Sir, you just made mention of the Supreme Court where you were talking about the Superior Court. So I want to know, is the Supreme Court the Superior Court? Because I was thinking that the Superior Court is a court that is higher than another one because we have hierarchy of court. So I thought that a Superior Court is a court that is higher than the other one, and the other one is called a lower court, which means a Court of Appeal can be a lower court to the Supreme Court. and the Court of Appeal can be a higher court, maybe the magistrate court. That was my thinking, sir.
Yeah,
I want to
you
know.
are still correct. You see, when the Supreme Court is standing, Court of Appeal is a lower court. The decision of Court of Appeal cannot be binding of Supreme Court. Where the High Court is a superior court to magistrate courts. So we have courts of records. We will later on in the, I think, second semester, we're going to deal with all of this. You will see the hierarchy of court. But the fact that we are saying that High Court is a superior court does not mean that the decision reached in High Court is binding on Court of Appeal or the Supreme Court. Do you follow now? All right. Let's go.
Thank you, sir. Thank you, sir.
Okay, so let's look at the disadvantages of judicial precedent. Judicial precedent has the effect of limiting judicial discretion. What that simply means is that if a judge is expected to apply discretion in a particular suit, because there is already an established principle or judgment, the judge is not allowed to do that. And then another disadvantage is that unjust legal principle can continue being enforced for many years until a later case, perchance, helps to correct it. I said that earlier, that if a particular judgment is arrived at by fraud, then it can continue to trend until maybe one way or the other it is addressed. So that is one disadvantages of judicial precedent. And it may also lead in some cases to premature crystallization of rules when in fact they were still only in their formative stage. That's another danger of judicial precedent. They can lead to premature crystallization of rules, especially when they are just being developed. Of course, Court of Appeal can develop, a justice of Court of Appeal can develop a rule, and then because he or she is sitting at the Court of Appeal, their judgment, if it is applied in a judgment, it becomes a law. And then, of course, it may not be a perfect rule to so apply, but because of what the doctrine preaches, it can trickle down like that. So, in effect, the future and the healthy development of the law is slaughtered on the altar of the obligation to apply the earlier decision. That is number 2. Number 3 is that a judicial error may be perpetrated until the legislature arrests it, or when there is public opinion or outcry on it. And then, so all of these they are the major challenges with the doctrine of judicial precedent. Okay, the possibility that a rule that is not of standard can trend, or that unjust legal principle can go sway is also there. So these are the major disadvantages of the doctrine that we have. There are still many which I will want you to go up and read up, and maybe we start with that in our next class as we review the class of today. But please go ahead and read that, and also read hierarchy of courts. Of course, you know how our courts are structured, starting from the Supreme Court down to the magistrate court, or even the other, other inferior courts that we have in our judicial system. Okay, so let me take one or two questions before we close. If there are still questions, okay. All right, I will open the chat box now so that you can send in your attendance, and then we can bring the class to a close. Any question?
Good afternoon, sir.
Yeah, good afternoon.
My question is, when a decision is made, let's assume it's by the highest court in Nigeria's case, the Supreme Court, it's valid forever, right?
I didn't get you clearly.
When a decision which makes case law, let's assume it's by the Supreme Court, which means it cannot be reviewed by a higher court. The Supreme Court is the highest court. How do you determine how long it is valid?
What? I didn't get that part, that last part.
How do you determine how long it is valid?
Okay, how are we going to determine how long it will be valid? Where?
For example, some decisions are made, they're not purely based on like pure law. Some include equality, public policy, and all that. What if the position of the public has changed and other factors also? How do you determine how does that make the law still valid, even though it may be harsh in the context of the modern world?
Well, I didn't get your question properly, but what I understand from what you are saying is that if a law was gotten what you consider as invalid, maybe by virtue of the fact that it was unjustly gotten, or it was based on a rule that was not, thoroughly checked, and then it continues, probably also made by the Supreme Court. For how long will it remain? The good thing about the Supreme Court is that the Supreme Court can correct such errors, because lawyers who appear before this court can make submissions about what they feel about those laws. And then the Supreme Court can still overrule itself, change the rule. Okay? That's one of the very nature of the Supreme Court as the apex court in Nigeria. Okay?
Thank you, sir.
Yes. Any other question? The last one. I'll take the last one.
Good afternoon, sir.
Good
Not a
afternoon.
question, sir. I didn't get the third disadvantages of judicial precedent emission, sir. My network logged me down.
Which one did you get?
I got the first two, sir.
The first one that I gave is that it may limit judicial discretion. Number two is that it may lead to cases of crystallizing premature rules. And the third one I gave is that it may make a judicial error to be perpetrated, made to remain in force for a long time.
Sorry, sir. Please, sir. I'm sorry. I know the other question was the last question. I mean, my friend's question was the last question. But, sir, please, what do you mean by premature rules?
Hello? I'm not sure you heard me. I just realized that I was muted.
Yes, sir.
What I was
Yeah.
saying is that in response to your question, is that a judge may formulate a rule, just like the rule we saw in Donoghue versus Stevenson, the neighbors principle rule, and apply if it is applied to in a case, and that particular rule becomes reason for the decision. That if it was not properly thought out before it was applied, it will make that same rule that is not thoroughly, worked out to become functional in the society. So that's what I mean. And of course, by virtue of judicial stare decisis, the rule is that you must apply that decision provided it's coming from a higher court on a similar fact. Thank you very much. All right, so we call it a day here. Thank you, and see you tomorrow. Have a nice day.